Hi, everybody. I promised now a few sessions ago that I would record a short video about the exam. Now, a few weeks ago, the recording didn't work in the room. I re-recorded the substantive session, but it is true that at the very beginning of that session, I had talked a little bit about the exam, and in particular, I'd given some examples of questions. So I want to take now just a few minutes to kind of go over those examples again, so that even those of you who weren't there have access to the same kind of instructions and material. Now, when it comes to the structure and the modality of the exam, we've talked about it in quite a few sessions. It's open book, as we said, which means any material you have, all your notes, your polycopier if you have it, books, electronic or non-electronic copies. You're going to come in, you're going to pick a topic, go in the back of the room, prepare for 15 minutes, come back, and then the exam will be 15 minutes. The first half, more or less, you will tell me about the topic that you picked, and I will be interacting. So don't expect it to just be a monologue, but maybe I will ask you questions, I will push you to go in a certain direction. And then the second half, I will ask you additional questions on, the rest of the class potentially, just to make sure that, again, you have a good understanding of the subject, not limited to the topic that you picked. And the exam can be in English or in French. You can even switch in between. Now, the kind of topics that you're going to get are going to be of two types. One type is an extract, so from a case or maybe like a paragraph of a decision, of a report of the appellate body, or of an arbitral award, or an article or a provision in a treaty. And if you pick, for example, I don't know, you pick Article 3 of the GATT, then I'm going to give you the text. You're also going to provide you with the printed version of the text. The other type of question is more of an open-ended question. And just let me give you an example of the primary source. Let's say I think I had given this example last time, right? I think I had used this specific paragraph from Abaclat, Argentina. Now, if you get this, for example, you need to think, okay, when did we see this paragraph? What were we discussing when we looked at this paragraph? So this was in the context of the definition of investment. It was in the context, in particular, of the risks of an open asset-based approach in the definition. And we saw that, in particular, this tribunal found that, again, something that might not be considered an investment, for example, under Salini, was instead considered an investment here because of the open-ended, nature of the provision. And then there is also an interesting reference to the preamble. So, for example, here, you could, frame it a little bit. First of all, you could talk a little bit about the facts. Don't go too much into the facts. I think it's good if you give some background, or this was a case between this and this, the case was about this. And we looked at this case in the context of definition of investment. And then you can take a little step back and say there is no definition of investment in any treaty. So it's very important to determine the scope, because that determines the scope ratione materia of international investment law. There are several approaches. Now, you don't need to go and explain all the different approaches. Now, this is about the open asset-based approach, so it's sufficient that you talk about that and explain that one of the possible approaches is open asset. What does that mean? What does it look like? It means that there is a list, but this list is just examples. It's really every kind of asset. And this has been interpreted very broadly, so a lot of different things can fall under this asset. And you can talk about this specific example, and you can, refer to the specific wording of the paragraph, right? Based on its wording, right? Article 1.1 cannot be seen to have intended to adopt a restrictive approach. So you explain that because of the open asset-based approach in the definition, here the tribunal found that even all these Italian nationals that had purchased part of the sovereign debt in Argentina, they could be considered as investors. I mean, their this link could have been considered as an investment. And you can even look at the preamble. And here you could say, and by the way, there is also reference to the preamble. You don't know what the preamble of this specific, Italy Argentina BIT is, but you can imagine that is going to be a preamble very much protective of investors. And so you can talk about the importance of preambles. There are different types of preambles, but of course, when you have a preamble that is very protective of investors, this can have an impact on the interpretation of other provisions, and this is a very good example, of that. Now, this is really a good answer. Now, you can even take it further, right? And you can say, that that first of all, you could, for example, start talking about other approaches, saying that there are other treaties that have kind of more limited approaches to try and limit what kind of activities can fall under the definition of investment. You can even couple of example. You can also, for example, point out that the reference to the treaty is sufficient outside of ICSID. If you are in the context of ICSID, we also need to look at the Salini test. So you can start to build. So what's important is that you immediately tackle the immediate topic, and then you can build on it. And then while you're building on it, if I'm content with what you've said, I can then stop you, or I can let you just speak if it's good what all the points that you're making. So this is just to give you an idea, okay? So it's going to be a paragraph that we have seen in class. This we saw in class, we talked about it. It's not going to be a paragraph that you have in the reading material, but that we did not see together. And it's going to be a paragraph that we have spent time on. So this was the first type. So the first type is that you get a reference to a paragraph of a case or a provision in a treaty, and then we give you the text. You go and you kind of do this kind of analysis. And you can make all the references you want, okay? What's important is that you really start by looking at the topic, then you can expand, but don't start, from the beginning, okay? Just try to really focus. The second type of question that you can get is more of an open-ended question. And then you just need to kind of think about when we talked about the topic and how you can structure properly your answer. Again, trying to address it to the point. I think that the example that I gave in class was something along the lines of the treatment of PPMs under the GATT. I think I said something like that. So process and production method under the GATT. Now, if you get this topic, you're only going to get your little topic. We won't give you any text. You go back and you think, okay, what is it that I can say about this? So don't start by telling me the origins of the GATT, because that's too much. I would stop you. But you can say, okay, when have we talked about PPMs under the GATT? Okay, so I can start by saying, first of all, very, very quickly you can frame what is the GATT, but in like 2 lines. And then you move to the issue of PPMs is relevant in the determination of a likeness, which in itself is relevant under the GATT when you talk about non-discrimination. And then you can quickly say non-discrimination. There's 2 dimensions, MFN and national treatment. In particular, likeness is a term that we find in different provisions, and you show me the provisions. Now, the issue of PPMs emerges when we discuss the different criteria for likeness. What are the criteria for likeness? You tell me what are the criteria. So the big question is, what about how a process is produced? Process and production methods. Is this a criteria? And then you can make a distinction between product-related and non-product related. If you have a case, for example, that is linked to that. And then you can even, you could even go a little bit beyond. We talked about this. I think we will talk about this maybe today, actually. But the fact that, what would be the added value? Should we allow PPMs or not? You could even give your own opinion. We said in class, and if we haven't, I will say today, that on the one hand, it does make sense to maybe create a distinction, but it could open a Pandora's box, and it doesn't allow us to go then to Article 20 to justify which provides checks and balances that allow us and help us to make sure that we filter out this gas protectionism. So you could even make this kind of considerations. You can even then, for example, say, this is very different from PPMs under the TBT. And then maybe I will stop you because that's not really your question. But if there's silence, you can, move on, and then I can either stop you or I'm interested in hearing how you compare it with TBT. So don't be afraid, but do not start with TBT. So first you exhaust your question, and then you can move on with comparisons. So again, we will have more time to talk about this. We will organize a Zoom session in January. But if I intervene, it's to really guide you. So don't panic and don't take it as something bad. Doesn't mean that you're wrong. I'm just trying to kind of guide you to, bring you back, or I'm just kind of pushing you to go, over a few aspects that I believe are important, and I want to hear your understanding and your view on those aspects. So I think I covered what I had said in class. And then for everything else, I'll see you in an hour, no, in 20 minutes. And then again, we're going to have one more session next week. And as I said, we're going to organize a little Zoom session in January to make sure that, every last minute question is addressed. Okay. I hope this was helpful. Thank you.